It's my pleasure to introduce Mary Lyons Anderson and Rich Goode of DePaul's Office of Advancement. These two members of the DePaul family are going to help us today to navigate through some of the choppy waters of estate planning. Mary Lyons Anderson serves as Senior Director, Planned and Regional Giving at DePaul University. And in this role, Mary focuses on planned giving while also serving as the primary fundraiser for the School of Continuing and Professional Studies, which was formerly SNL. Prior to moving to DePaul, Mary served as Director of Gift Planning for Northwestern University. Mary earned her Bachelor of Arts from the University of Notre Dame and her Juris Doctorate from DePaul University College of Law. Mary serves on the Board of Trustees for Sacred Heart Schools in Chicago and the Board of Directors for the Chicago Council on Planned Giving. Rich Goode graduated from Notre Dame Law School, and he practiced law in downtown Chicago until 1995, when he left to devote his energies to fundraising in the area of planned giving. After stints at the Archdiocese of Chicago and the Lurie Children's Foundation, Rich joined the advancement team at DePaul in 2017. In his 25 years in the field, Rich has spoken and published articles on the topics of estate planning, charitable giving, and fundraising. I want to thank Mary and Rich for their strong commitment to the Vincentian mission and the Vincentian value system of our great university. Mary and Rich, we're looking forward to your thoughts on estate planning today. Thanks for helping us.
Well, thanks everybody. And it's good to have so many people on the webinar today. We overtook wine tasting for the most well-attended webinar since the lockdown began, which I consider a great triumph that we could beat out wine tasting and when the topic is estate planning. So thanks for your interest. One more little housekeeping thing. I think what we're going to do is Mary will collect all the questions and maybe we'll take care of those at the end. And what we're going to lean towards, because we probably won't be able to cover all the questions, we'll lean towards the questions that are more general in nature. If you have a question about your own personal situation, you can reach out to Mary or I, and we'll schedule a separate meeting with you and take as much time as you like to go over your personal situation one-on-one. We'll field a few of the more general questions at the end of this seminar, but then this seminar does not end with the end of the Zoom meeting. We're happy to pick up with you and answer your questions about your personal situation. So real quick, what are we going to cover today in our estate planning discussion? Obviously, we're going to talk about wills, how they work. We'll talk a little bit about probate and the probate process. But really, I want to stress the importance of having at least a will. I always say every adult should have an estate plan, and the will is the cornerstone of an estate plan. But we'll go beyond wills. We'll talk about trusts. Actually, before we part today, we'll talk about a few different types of trusts. We'll talk about, in general, how trusts work, but we'll talk about revocable living trusts, which many of you may have heard of or already have. We'll talk about something called a life insurance trust briefly, and we'll go into some detail about a charitable remainder trust. So we'll get into it on trusts. We'll talk a little bit about life insurance, but we'll go into great detail about taxes. Not so much the income tax. We're going to talk to you more about estate taxes and how estate taxes work. We'll talk to you about living wills and durable powers of attorney for healthcare today. And we'll also talk about the possibility, if and only if it makes sense for your family, of including DePaul University in your estate plan and some ways to do that that are tax efficient and maybe meet other family needs at the same time. But my first priority, as I said a minute ago, is to convince you that every adult needs an adequate estate plan. And when I when I talk about doing estate planning seminars, a lot of people say, well, I think most people have that taken care of. And I say, well, maybe, but there's a lot of people that don't. And I'm trying to get my thing advanced here. There we go. Does anybody remember the name Chief Justice Warren Burger? He was the Chief Justice of the Supreme Court, and he did not have an adequate estate plan. There's a copy of his will that he did before he died. It wasn't witnessed properly. It didn't give his executors the powers they need to do things like sell his property. It was wholly deficient. And the worst part of it was it did nothing to minimize estate taxes, and his estate ended up paying almost $500,000 in estate taxes. And at the end of this article, they interview a lawyer and they say, what about those estate taxes? And it's the lawyer's opinion that he could have avoided estate taxes completely if he had done an adequate plan. And they asked the lawyer, how much would you have charged him to draw that plan up? And the lawyer said, probably about $2,000. Now, $2,000 is a lot of money in my book, but a $2,000 lawyer bill to save a $450,000 tax bill would have probably been one of the best investments he ever made. So not everybody you think has an adequate estate plan, and Chief Justice Burger fits in that category. What I'm going to do to get our discussion started is I'm going to give you a little bit of a test, and you can just take the test as you're sitting there in your head, but it helps me to kind of frame the discussion a little bit. So question number one, true or false, I have a will. Again, your will is the cornerstone of every estate plan. You should have at least a will, and we'll go into wills in more detail. Number two, my immediate survivors know where to find my will and other estate planning documents. Very, very important that you keep your estate planning documents in a safe place and you let 2 or 3 people know where they are. In the case of a will, you need the original will. It can't be a photocopy. The original will needs to be presented to the probate court. And in my 25 years in this field, I have had to try to prove up a photocopy of a will, and it's very, very hard. So you need to keep the original documents in a safe place, let somebody know where they are. Some examples of safe places are safety deposit boxes. I have one of those fireproof lock boxes in my closet, and that's where I keep all my important papers. But very important that you have these documents in a safe place and that you let some loved ones know where your documents are being held. Question number 2 or 3, my executor and alternate executor are still capable and qualified to serve. So let's talk about the job that an executor does. And by the way, if you have a revocable living trust, that role will be fulfilled by someone whose title is successor trustee. So when I say executor during this part of the presentation for you, I mean successor trustee. Successor trustee. So basically, there are 3 jobs for an executor when they're wrapping up someone's affairs. The first job is to marshal the assets of the estate. So they pull together everything that the deceased person owned. The next job, number 2, is to pay the debts of the estate. So they pay all the debts that the deceased person owed. And job number 3 is to distribute the estate as directed in the will or trust. And when I put it that way, it sounds fairly simple, but I'm sure that some of you have served as executor or successor trustee, and you know that it's not a simple job. It's not an impossible job, but you have to be organized. A couple of things that have to be done is, a house might need to be sold. You're going to have to help someone or yourself file the final income tax returns for the deceased individual. Again, pay all their other debts, wrap up their affairs. So in choosing an executor, you want to choose someone who's organized, who stays on top of things, who has some time to devote to this. And you always want to have at least 2, a first choice and a second choice. And it doesn't hurt to also have a third choice. And it's a good thing to think about these things before you go to see a lawyer, because you're going to be asked that question. It might save another meeting if you're ready, if you do that. So very important to think about who would be able to serve as your executor, first choice, second choice, maybe even a third choice. Number 4, my guardian and alternate guardian are still capable and qualified to serve. You know, we're going to talk today a lot about taxes and money and property and assets, but the most important thing that an estate plan allows us to do is nominate a guardian for our most vulnerable family members. And usually that means minor children, but it can mean an adult child who has a disability. It can mean an elderly spouse or elderly parent who we're responsible for. But your will gives you the opportunity to nominate a guardian for those family members that may need help if you're not around. And it really is the most important thing that your will allows you to do. So another thing to do before you walk into a lawyer's office is think about that. Who would you want to serve as guardians for those family members? And again, a first choice followed by a second choice. So again, most important thing that your will allows you to do. Question number 5, my executor is knowledgeable in these matters and knows how to find the necessary information to settle my estate. So we said that the job of an executor is to pull together everything that we own and then to pay all our debts. Wouldn't it be helpful if that executor had some idea of what we own and what we owe? And the answer is, of course. But, you know, if I tell them today, a few things they won't remember. It might be completely different by the time they have to act as my executor, that information. And lastly, I don't want to tell them everything I own and everything I owe right now. What you want to do is kind of be organized. And actually, I have a little booklet here that you'll be able to get. It's an estate inventory that I put together. And it's just a place to list everything that you own and then everything that you owe and figure out your net estate. And the primary use of something like that is to fill it out before you go see a lawyer to do your estate plan. And not only do you list your assets, but you break them down into, how do I own that asset? Do I own it in my own name? Do I own it jointly with someone else? Is it inside an IRA or other retirement plan? Is it in a trust? Is there already a beneficiary designated on that account? Your lawyer is going to be very interested in all that information. So the primary purpose of that booklet is to have all your ducks in a row before you go see a lawyer. But a secondary use is that if you fill it out and you keep it updated, and then when you're done updating it, you paper clip it to your other documents, your will and your trust, then when they need to find your will and your trust, they have a fairly updated account of what you own and what you owe. So you're making things easy for those who have to settle your affairs. And I'll tell you how you can get your very own estate inventory at the end of the presentation. But a real good idea to be organized and make things easy on those who have to settle our affairs. And the estate inventory is one good way to do that. All right, question 6. My lawyer has offered to review my estate plan to ensure its compliance with recent tax reform laws. So the point here is you can't do your will or your trust once and then forget about it forever. And one of the reasons is that laws change periodically. They change the amount of estates that will be subject to taxes, things like that, and you need to keep an eye on that. But more often than laws change, we deal with in the next question, my survivor's financial needs have been reviewed and appropriate steps have been taken to meet them. Your family circumstances change periodically. You want to make sure that the people that you have remembered in your will are still living. You want to make sure that they, still need the money. Maybe they are now disabled and it's not a good idea to leave them money outright. You need to leave it to them in some sort of support trust. The point of both of these questions is you need to review your estate plan periodically. And here's what I recommend. Remember when we used to have paper calendars? I still have a paper calendar. I'm kind of a dinosaur. And every time when I first get it, whatever date it is, I wait till after New Year's because they're cheaper after New Year's. So, January 5th or something. And I write down all my family's birthdays and anniversaries on the calendar the day I get it. By the way, when I do that, it's my hand gets tired because I happen to be the youngest of my parents' 12 children. So it's a lot of writing, and they're all married and they all have kids. And the only reason I mentioned that I'm the youngest of 12 children, is my mother told me to always mention you're the youngest of 12 children. She said people like that. So I always slip that in there. So that gets that in there. But anyway, I look at my estate plan. On the calendar, I write down on a Sunday in November. I don't know why I picked November. I write down, review your estate. And on that day, I see that and I just think for a minute, do I need to update anything? Is everything still the way I want it in my estate plan? And most years, I don't even have to pull the documents out of the drawer, out of the lockbox, because it's like, no, I know everything's all set in there. But you want to review your estate plan periodically. Just think about it periodically. Certainly if you move to another state, or if there's a substantial change in your financial situation or your family situation, it's important to review your estate plan periodically. Question 8, the financial benefits for any minor children named in my estate will be provided for in a trust. So not only minor children, but sometimes other vulnerable adults, family members and loved ones, you don't want to leave them money outright. You want to leave it to them in a trust. And we'll talk about trusts in just a few minutes, but a trust is very important. So again, if you are on this webinar and one of your motivations for doing an estate plan is that you started a family recently, you really need to have an estate plan. I would say every adult needs to have an estate plan, but if you have minor children or vulnerable adults that rely on you, you really can't go another month without an estate plan, because it's your opportunity to nominate guardians and trustees so that those folks are well taken care of. Question number 9, my survivors have been briefed regarding key people they could consult with in decision-making situations. Again, the people that have to settle your affairs, it would be helpful for them to know if you've been working with an accountant or someone to do your taxes for many years. That would be good information for them to know, a financial planner, etc. And that's information that you can put in your estate inventory. And if you have that clipped to your estate plan, they'll find it when they need to find it. But all about making things orderly so that people have an easy time of it when they are ready to settle your affairs. Finally, question number 10, after family needs have been met, I've considered sharing my estate with charities that have touched my life and I see doing good in the world. Your estate plan is important for many reasons, but it's more than just a stack of legal paper. It's a statement of what you cared about and what was important to you during your life. And for most of us, family comes first. Of course, family comes first. But for many of us, each and every year, after helping out family and making sure those responsibilities are taken care of, we do something for charities that have touched our lives, that we see doing good in the world. And that's a value that can be carried over into your estate plan. The values of just helping others through a gift to charity. And we'll talk a little bit about some creative ways to do that. Most people just do it with a percentage of their estate in their will, but there's other ways to do it, maybe even some more ways that are more effective from a tax standpoint, and we'll talk about that. But yeah, so you know how you did on your estate planning test without looking down. If you mark number 1 false, it means you haven't gotten started. You don't have a will yet. But the good news is you're here, so you know it's important and you can do something about it. And some of the other ones, maybe if you mark them false, just a little bit of work to do, but that's why we're here. So anyway, why don't we get into the meat and potatoes of this thing? I have it organized on this little outline by estate planning considerations. Again, I'm going to sound like a broken record, but your will is a cornerstone of an estate plan. Every adult should have a will. But a lot of us have heard about trusts. So I want to talk in detail right now about how trusts work. And then I want to talk in detail about a certain type of trust that many of you probably already have, called a revocable living trust and how that works. So the way that I frame it is that there are 5 parts to any trust. The first thing, to have a trust, you have a person like me or somebody who has some assets, and they want to manage those assets and use a trust to help them manage those assets. So what they're going to do is change the title of those assets out of their own name and into the name of a trust. Then they are going to appoint a trustee to manage those assets. And the trust document will give that trustee either complete power or limited power to manage the assets in that trust. Then the trust document will name certain payment beneficiaries who will receive benefits from that trust. So, the trust term may be 10 years. It may be a trust that says, pay Mary all the income that the trust earns for 10 years. Or pay John income and principal as needed for his health, education, and support for the rest of his life. The term of the trust could be John's life. The point is, though, that trust will have a term, and eventually that term will end. And what happens when the trust term ends is that the trust wraps up, and whatever assets still remain in that trust will be distributed once and for all to the remainder beneficiaries that were named when I set up that trust or when whoever set up that trust. And that's the 5 parts of any trust. Let's talk about something called a revocable living trust. A lot of us have revocable living trusts as kind of like a will substitute. But I will say, even if you have a revocable living trust, you still need a will, and I'll explain that in a minute. So let's use me as an example. Suppose I wanted to use a revocable living trust as my primary estate planning vehicle. What I would do is I would take every asset that I could, pretty much all my assets, change them out of my own name, and title them in the name of the Rich Goode Revocable Living Trust. Well, that sounds kind of scary, right? Because I no longer own my own assets. Here's why it's not so scary. I'm going to name myself the trustee of the Rich Goode Revocable Living Trust. And that trust document's going to give me the power to do whatever I want with the assets in that trust. I'm also going to name myself as the payment beneficiary of the Rich Goode Revocable Living Trust. And again, the trust document will give me all the rights and responsibilities of ownership of the assets in the trust that I had before I set up the trust. So it's going to be just like I still own it in my own name, but I'll have it in this trust for estate planning purposes, which I'll explain in a second. And the IRS will realize that it's really not a separate ownership, and that trust will share my Social Security number with me during my life. So I won't have to do another tax return for the trust. I'll just do my own tax return, and any income, anything from the trust assets will just show up on my own tax return during my life. So it's literally just like I own the assets in my own name. A big difference comes at the end of my life. Because I don't own those assets legally, because they're owned by the trust, those assets will not pass under my will. What will happen to the assets in the trust at the end of my life? Those assets will go to the remainder beneficiaries that I named when I set up the revocable living trust. So the trust will wrap up at the end of my life and will distribute all the assets to the remainder beneficiaries that I set up, that I put in the document when I set up my trust. So the same people that would have been legatees in a will are now called remainder beneficiaries in my revocable living trust. And my trust will act exactly as my will would have acted. It will distribute my assets to my loved ones through the trust, except they'll be called remainder beneficiaries instead of legatees under a will. So you can see that in that way, the trust acts as a will substitute. It does the job we normally associate with a will. It distributes my assets at the end of my life. Why did I say earlier you still need a will even though you have a revocable living trust? Well, what you do when you have a revocable living trust is you have a very simple will called a pour over will. And that will says something like this: I, Rich Goode, give everything I haven't already given to the revocable living trust, that I haven't already put in there, to the Rich Goode Revocable Living Trust. And then all my eggs end up in one basket, and they're all distributed to the remainder beneficiaries at the end of my life. So why would someone choose to do a revocable living trust instead of just a simple will? Well, there's a lot of reasons, but some of them are: one is disability planning. Trusts can be very helpful. If I am no longer able to manage my affairs, I've named a successor trustee in that trust, and they can just step in and manage my assets. There won't need to be any sort of guardianship proceeding. Now, you can do that if you just have a simple will and you don't have a trust, through a power of attorney for property. But some would say the trust makes it a little cleaner. Another big advantage that's often touted about revocable living trusts is that it gives you the opportunity to avoid probate. So I want to walk a thin line here. It is a good idea to avoid probate. It's great to avoid probate. But I don't want you, if some of you are out there and you don't have a trust, you have a simple will, to be scared to death of probate. For most of us, probate is not complicated. It's not terribly expensive. It's only if a will is going to get contested that it gets expensive, and most of our wills are unlikely to get contested. So I don't want you to be nervous about probate if you don't have a revocable living trust. But that being said, it's nice to avoid. In Illinois, 99% of the time, or 95% of the time, probate involves 2 5-minute appearances before a judge, one to open the estate, one to close the estate. It's not a big deal. Some of you are coming from other states. I would imagine it's true or similar in your state too. For regular estates. Another advantage of a trust, though, is that a trust does remain private. When I pass away, my will goes on file down at the courthouse. Someone wants to check it out and read it, they can. I don't think anybody's going to be interested in reading my will, but I think Frank Sinatra or somebody rich and famous probably doesn't want everybody digging into their personal affairs, so they would do a trust for privacy purposes. And last but not least, we're going to talk about estate taxes in a little while. If you're lucky enough to have an estate tax problem, because it means you're fairly wealthy or very wealthy, then you want to have a revocable living trust to help you with the tax planning that you need to do. Again, I want to walk a thin line here. Revocable living trusts are great. They're great tools. Often it's not a question of needing one, but just wanting to have one, because it's a little, you feel like it's more orderly. But I don't want anyone out there who only has a simple will to think that you're up the creek, because wills can work fine too. Usually for a simple estate, probate is not too onerous, and a will can be just fine. You may not need a revocable living trust. So again, we can talk to you in more detail, either one-on-one or through the chat feature, if you have questions about revocable living trusts. But they're very common estate planning tools, and I just wanted to spend some time on them. So back to our estate planning considerations. A little bit about life insurance. A lot of people have a lot of theories about life insurance. I do have a lot of life insurance right now because I have 4 kids who I want to make sure would be taken care of if something happened to me. I'll probably ramp down my life insurance in about, 10 years, when my oldest is out of college and my youngest is out of college. But for now, I have a lot of life insurance. One thing I wanted to mention about life insurance, it's generally not subject to income tax. So I get a $100,000 policy. I leave it to my nephew, or make my nephew Jack the beneficiary. I die. He gets $100,000. He doesn't have to pay income tax on that. Most gifts that I make are not subject to income tax. There's some exceptions. We'll talk about that in a minute. So I could leave someone $1 billion and they wouldn't be have to pay income tax on that. May have to pay estate tax. We'll talk about that next. So life insurance not subject to income tax, but it can be, pardon me, it can be part of our estate for estate tax purposes. And there's a way to structure life insurance so it doesn't end up being part of our estate. And I'll talk about that at the end of the presentation. It's something you may want to consider if you have a big life insurance policy. Now, this is the fun part. Let's talk about estate taxes and gift taxes. Um, and I want you to think about these two taxes. One way I've explained it over the years is like the mirror image of the income tax. Think about how the income tax works. With the income tax, when I bring money in, the government wants a piece of the pie, right? And the receiver of the money is the one who pays the taxes. As the income earner, I pay income taxes, right? Well, the gift and estate taxes are like the mirror image of that. If I'm giving away money, the government might want a piece of the pie. And it's the giver of the money, not the receiver, who pays estate and gift taxes. So the way I've talked about these, they're transfer taxes. They're taxes on transfers of wealth, as opposed to income taxes. So let's talk about how the federal estate tax works. Suppose I died with an estate of exactly $11,580,000. I would have a tax on that estate when I try to transfer it to loved ones of $4.6 million. That's a heavy tax, right? Here's the good news. I have, you have in 2020 an estate tax credit of $4,632,000. Tax credits are better than tax deductions because they totally eliminate the tax dollar for dollar. So if I have a $4.6 million tax and a $4.6 million tax credit, theoretically, my estate tax due should be zero, right? But of course, I have to put maybe there because it's never that simple. The estate tax has to interact with the gift tax, okay? So let me describe how the gift tax works. There's a $15,000 yearly exemption from the gift tax. So in other words, I could give everyone on this meeting, everyone on this Zoom call, $15,000 today, and none of those gifts would be subject to gift tax. I wouldn't have to pay gift tax on any of those gifts. So suppose I did that. I gave everybody $15,000. And then because I was grateful to Emily for putting this together, I gave Emily another $10,000. So I gave her 15 today, and then tomorrow I gave her 10. So that $10,000 now is a taxable gift because I've used up my annual exemption for 2020 for Emily, and the next gift I give her is taxable. So I have a $10,000 taxable gift. It's the first time in my life I've ever made a taxable gift. So the tax is 18% or $1,800. Now, as you do more and more taxable gifts, your tax rate goes up, similar to the income tax. But for my first one, it's 18%. So do I have to file a gift tax return next April? Yes, I do. Do I have to write a check to the IRS for $1,800? No, I don't. Why? Similar to my estate tax credit, I have a gift tax credit that shelters $11.58 million in taxable gifts. So the point here being, I can shelter $11.58 million in taxable gifts at my death or during my life, but I have to choose between them because any taxable gifts I make during my life are treated as if they are still in my bank account or part of my estate for estate tax purposes. How's that for record keeping nightmare? I have to keep track of these gifts to make sure that I pay whoever pays the right amount of taxes at the end of my life. Here's the good news. Most of us don't have to worry about estate taxes. Most of us aren't making taxable gifts, first of all. But even if we are not worth $11.58 million, so we don't have to worry about exhausting our tax credit during our life. So it's really no big deal. Once the estate tax kicks in, however, if you are lucky enough to have that level of wealth, it's a heavy tax. Federally, it's 40%. States like Illinois have estate taxes. In Illinois, it goes all the way up to 18%. Combining those, it could be 50% or more of the taxable portion of your estate going to taxes. So if you have a taxable estate, lucky you, but it behooves you to do some planning. Now, a couple of wrinkles on this. just so you know. All bets are off between spouses. You can transfer an unlimited amount to your spouse during your life or at your death, and none of those transfers will be subject to gift tax or estate tax. Also, spouses can combine the $15,000 per year gift tax exemption. So I can give Emily $15,000. My spouse can give Emily $15,000. We've just gotten $30,000 over to Emily without any gift tax. And married couples can combine their credit. So basically, a married couple in 2020 can transfer $23 million plus to their loved ones without triggering a federal estate tax. Now, if they live in a state like Illinois, Illinois' estate tax kicks in at $4 million. They might have some state estate tax. But I think you can see that this tax affects the wealthy for the most part. And 99+% of the country is not affected by the federal estate tax. But for those of us that are, it's worthwhile to make a plan, because like Chief Justice Berger found out, you can save hundreds of thousands and even millions of dollars by putting together a good plan. So that's the estate tax. That's the most complicated thing. If you're still awake, we won't talk about that anymore for the rest of the afternoon. So we talked about all this stuff. Want to talk briefly about charitable giving through your estate plan. We talked about how your estate plan is, is more than just a stack of paper. It's a reflection of the values that you have held during your life, and in that sense, you might want to make gifts to charity. And one thing I want to mention: all gifts to charity are not equal. I said earlier that for the most part, gifts that I give to people during my life or at my death are not subject to income tax, right? But there's some exceptions to that rule. And the big exception is my retirement plans. Not a Roth IRA, that's a little different, but most retirement plans, when I leave that to loved ones and they withdraw money from that plan, they will pay income tax on that withdrawal. So a big asset in most of our states, the retirement plans, is subject to income tax, which makes retirement plans a great asset if you're going to leave something to charity. Retirement plans are a great asset to leave to charity because you're leaving an asset that has a tax burden to an institution that doesn't pay taxes. So if I'm leaving a $100,000 retirement plan to a loved one that's in a 30% tax bracket, they're only going to keep 70 cents on the dollar. If I leave that retirement plan to DePaul, DePaul gets $1 on the dollar. It's like having Uncle Sam chip in 30% of my gift, which is a pretty good deal. Plus, these retirement plan gifts are easy to make. If I already have an estate plan, I don't want to see a lawyer to revise it. All I got to do is call Fidelity or Schwab or wherever I have my retirement plan and ask for a new beneficiary designation form. And I can put DePaul on the beneficiary designation form, send it back, and that's all I need to do. I don't need to see a lawyer. I don't need to pay a lawyer's fees. I'm all set. And then if you wanted to designate that money from your retirement plan to some particular area of DePaul or create an endowed scholarship fund with that gift, Mary and I can help you with that. You don't need to try to write it in on the little line on the beneficiary designation form. We can create a document that makes sure that any money we receive from the estate will go exactly where you want it to go. Real quick, I want to talk about living wills and durable powers of attorney for healthcare. Any lawyer that does your estate plan is going to ask you if you have these, so let's talk about what they are. A living will is a statement of what you would want to happen to you if you were ever in a situation where you couldn't make your own healthcare decisions. And it usually says something like, if I have no chance of recovery and I'm no longer functioning, my brain is no longer functioning, I don't want attempts to preserve my life to continue. So you have a living will. You also want to have this durable power of attorney for healthcare. What's that? A durable power of attorney for healthcare. Well, a power of attorney, when I'm giving someone power of attorney, they have the power to act on my behalf. So a durable power of attorney for healthcare gives someone the power to act on my behalf in situations where I'm not able to express my own healthcare preferences. I'm still alive, but I can't express my own healthcare preferences. Then this person would step in and act as my power of attorney. The doctors would listen to him or her. So it's very important that you have a living will and a power of attorney for healthcare. The power of attorney for healthcare is actually the broader of the two. If someone has the power of attorney for healthcare, they will listen to that person, but you have the living will there as a fallback. Okay. All right. Real quick before we finish up and field a couple of questions, I think I'm okay on time. I want to talk about a couple of ways, tax effective ways to include DePaul or other charities in your estate plan. As Judge Learned Hand says, there's nothing wrong with trying to minimize our tax burden, and that's what these two plans do. So first I want to talk about a charitable remainder trust opportunity. Now this one, you want to fund it with a fair amount of money. If this sounds like a big dollar thing and it doesn't apply to you, stick with me, because the next option very possibly could. All right, so let's talk about how a charitable remainder trust was. I'm going to do this as an example. In this example, I have mom and dad. It doesn't need to be a married couple. Single people can do these just as well. And they let's assume that mom and dad they have a taxable estate, and one of the assets in their estate is some stock worth $300,000, and it's high growth stock. So they have a $270,000 gain, and it doesn't pay a lot in dividends, maybe $3,000 a year. Now, mom and dad have some estate planning goals. One of their goals, like most of us, is to keep taxes low, to leave the majority of their estate to their family. But another goal is they're grateful for the education they received from DePaul, and they want to make a gift to DePaul through their estate plan. So right now, what are some of their options? Well, one thing is they could sell that stock and then leave whatever is remaining after capital gains taxes to their kids. They don't like that plan because it gives the IRS two bites at the apple. One, when they sell the stock, they have to pay a huge capital gains tax. The other, when they die, I told you they have a taxable estate, that half of what's left will then go to state and federal government. So they don't like that plan. And they're also a little worried because this is all in one company, right? Maybe it was the company that she worked for, and it's not very diversified. So they'd like to diversify. And so another option would be to just keep the stock. It would avoid the capital gains tax if they kept it, but they're worried about the diversification. They're not very diversified. And again, they want to help DePaul. So what they're going to do instead is they're going to take that $300,000 worth of stock and they're going to contribute it to a charitable remainder trust. And that charitable remainder trust will be able to sell that stock and reinvest those assets without triggering an immediate capital gains tax. So they like that. They get to diversify without a big immediate capital gains tax hit. Plus, it's going to pay them 5% a year. So in the first year, they get $15,000. They were getting $3,000 a year. Now they're getting $15,000. So they like the increased income that the trust gives them. So right now, they have some pretty nice benefits from having created this trust. One is they get to diversify without triggering a big capital gains tax. The other is they increase their income. And lastly, they get a big charitable deduction. Now, they don't get a $300,000 charitable deduction because they're keeping the right to receive an income for the rest of their life. Their deduction will probably be somewhere between $130,000 and $150,000, which is really helpful. So during their life, three nice advantages: diversify without triggering an immediate capital gains tax, increased income, and a really nice tax deduction. What about at the end of their life? Well, we know at the end of their life, DePaul will get a gift. Oh, I just undid this. Sorry about that. DePaul will get a nice gift, and it may even be more than $300,000 if the trustee does better than 5% on the investments. That trust could grow and maybe even be $350,000 or more. But that depends on how well it does in the stock market. But there'll be a beautiful gift for DePaul. But what about the son and the daughter? Well, we're not going to forget about them. We want to set up their legacy in a tax-wise way. So some of this additional income that mom and dad had, they're going to direct to something called a life insurance trust, an irrevocable life insurance trust. And they're going to use that additional income to pay the premium on a $300,000 second to die life insurance policy. So again, during mom and dad's life, they get the increased income, they get the ability to diversify, they get a huge tax deduction. At the end of mom and dad's life, they make a wonderful gift to DePaul, and the kids receive $300,000 from the insurance policy, free of income tax, because gifts are, insurance proceeds are always free of income tax. And it's not part of their estate for estate tax purposes because they set up the life insurance trust. You could make an argument that the kids will get even more than they would have gotten if mom and dad didn't put this plan together, because the $300,000 of stock, if they had just kept it in their estate, would have been subject to a punishing estate tax. And the way they set this up, not only do they get $300,000 to their kids, but they make a really, really fabulous gift to DePaul to pass along the benefits that they got through their DePaul education. So you might say, Rich, that sounds like a great plan, but I have nowhere near that kind of money. I like the idea of a vehicle where I can make a gift today, get a tax deduction today, and DePaul gets a benefit at the end of my life, and I get income for the rest of my life. Well, there's another way to do that. So this is a quick example called a charitable gift annuity. Again, another way to make a gift now and get an income for the rest of your life and help DePaul. So you got a guy named John. He's 85 years old. You don't have to be quite that old, but you do have to be of a certain age. Gift annuity, our minimum is 60 years old. So anyway, here's John. He's 85 years old. Let's suppose he's got $100,000 in a CD that's coming due, and he's trying to figure out whether to roll that back over into another bank CD. And he Googled CD rates, which I just did before this presentation, and the highest one, well, I read the averages. The highest one of all the averages was 0.6%. So he's like, oh, that's not very much money. And he wants to make a gift to DePaul through his estate. So what John might choose to do is do a charitable gift annuity with that $100,000. And if he did that, DePaul would be able to pay him. This is based on his age. The older you are, the higher your annuity rate is. DePaul would be able to pay him 6.9% a year, or $6,900 a year for the rest of his life. That's a lot more than he was getting from the CD, but I don't want to compare this to the CD, because at the end of the CD term, what does he get? He gets his 0.6% or whatever he can get, but he also gets his principal back. The way a gift annuity works is John would get the $6,900 a year for the rest of his life. And at the end of his life, whatever remained of that $100,000 in principal would go to DePaul for a scholarship fund to help the school that he attended, to help first-generation students, whatever he wanted. So it's not really comparable to a CD, but it's a good plan for John at this point in his life. Not only that, but John gets a nice tax deduction, $45,000 tax deduction. And on top of the tax deduction, which he loves, for a number of years, for 9 years in John's case, that $6,900 will be mostly tax-free. After 9 years, it'll all be ordinary income. But for the first 9 years of him receiving that income, till he's 94 years old in his case, about $6,000 of that $6,900 will come to him tax-free. So gift annuities are great. You can fund them with less money than you need to start a charitable remainder trust, but they work very similarly in that donors can get an income for life and make a gift to DePaul at the same time. Real quick before I go on, I just want to, we're pretty much done. I got one other thing I want to talk about and one other thing I want to say. One is, of course, thank you for coming. We really appreciate your interest in this topic. I think I'm still on time, although I'm getting close, sorry. We will field questions one-on-one if we don't get to too many or people have to jump off this presentation. But I do want to say one thing. If a gift to DePaul through your estate plan made sense for your family, DePaul would be a worthy beneficiary of that generosity, folks. I'm so proud to work here. We're doing good things here. We're helping people transform their lives through education. And Mary and I are available to help you set up your estate gift so that you're sure that when that money comes in, it's used for exactly what you want it to be used for. And we would love, love, love to help you with that. You can use it to set up an endowed scholarship. You can use it to do all sorts of great things for students at DePaul. Real quick, I want to mention that right now, there's a wonderful opportunity to have a gift matched. Mr. Hay was a wonderful supporter of DePaul and member of the Board of Trustees. And through his generosity, from now until December 30th of this year, if someone makes a gift of at least $25,000 for an endowed scholarship, the Hay estate will match that with $25,000. So if you give $25,000, the Hay estate gives $25,000, you can have a $50,000 endowed scholarship fund set up in your name, or to honor a loved one or a favorite professor. So we would love to field your questions on that. Doesn't have to be just 25. A gift of 50 will be matched with $25,000, 75, and so on. So again, thank you. Real quick, I just want to mention that Mary and I are available to help. If you want to talk to us or set up a separate meeting with us, there are our emails and phone numbers. You don't have to write them down now because you will get copies of this presentation. If you want to get your estate inventory, please email us and let us know, and we will send that to you. Happy to discuss with you your own plan, your own personal questions. Of course, happy to discuss with you the possibility of including DePaul in your estate plan. Again, I went a little long here. There'll be by the way, there will be a survey sent out after this presentation. That's another way you can fill that out and request the inventory when you fill that out, or request a meeting with Mary or I. Mary, maybe we could do a couple of questions before we sign off.
Sure. So as Rich mentioned, there was a question about whether or not today's webinar was recorded, and it was, and so we can certainly send that out to you. And if you include in an email that you'd like a copy, that would be great. We'll make sure it gets to you. One person asked if there are any fees associated with talking to you or me, Rich. So.
Oh yeah, no, of course not. And not for the first time we talk, not for the second time we talk, not for the 10th time we talk. So consider us at your service. And it's just something that we, the university provides. Obviously, the hope is that some of you will, why not all of you, will include DePaul in your estate plan, and that's so appreciated. But either way, if you're not at that point in your life where you're able to consider that, this is an open invitation, no charge. We're happy to chat with you. We can't be your lawyers and do your estate plan, but we can certainly answer your questions, help you get your ducks in a row before you go see a lawyer. And maybe if you don't have to ask the lawyer certain questions, you get charged a little less because you're not using up as much of his or her time, right?
And we can certainly be helpful in terms of recommending a list of attorneys. I know oftentimes people have questions about how to find an attorney to be helpful, and so we can pull together a list for you where you could talk to them. And most people are willing to meet virtually at this point for a short time, just so you can feel comfortable with the attorney you ultimately hire, and that's usually free of charge. Someone also asked what the best way is to leave something to a minor.
Yeah, I tried to hit on that earlier. Now, again, it depends really on how much money we're talking about. If you are that minor's parent and you are leaving, you're on the possibility, the rare possibility that you will pass away while they're still minors, you definitely want to leave that to them in a support trust. And your lawyer will help you with that, and you will nominate a guardian and trustee to manage those assets for that minor's well-being. If you are a grandparent, you just want to make a gift to that minor, you can do that through their parents, through this, there's a Transfer to Minors Act that's been adopted by most states, where the parent would have the responsibility to use it for the benefit of the child. However, if that child is someone where you're not comfortable leaving it to a guardian, you can set up a trust even for that gift to that child. So it really depends on your situation what the best route for leaving a gift to that child is. Don't you think, Mary?
Yes, I definitely agree. And one question that just came in too that could be relevant to everyone on the webinar is, how do you choose the best executor? Do you have any recommendations along those lines?
Yeah, I do, and I'm sure Mary, you would agree. Again, I think the most important thing is somebody who's organized, and because they're going to have to be very transparent during this process, and that's really important. When estate situations get ugly and when feelings are hurt is when people don't know what's going on. So what you want is an executor who's going to report out to people while the process is going on about how much money is in the estate account now, what bills have been paid, how long is it going to take to wrap up these affairs and get their distributions made. So you want to pick somebody who's got that skill of organization. Again, they're going to have to keep the record straight so they can get the information to whoever's doing the final tax returns and things like that. They're going to work with a lawyer to guide the estate through probate. And I would even say if that person is out of state, that can be okay. It might be a better choice. I have been involved with estates where the executor was out of state, and maybe there's some FedEx charges to send documents back and forth to be signed, but it's not the end of the world. So I think that's the single most important thing when choosing an executor, someone who can be organized and communicative. So anything you would add, Mary?
And just confirming that they're willing to serve in that way too. Having the conversation, I think, is helpful. And that way, if there's something you're unaware of, or if they'd really prefer, they have too many things going on where they don't know that they could commit to something like that, they're able to tell you that, and you can move on to choosing someone else.
Yeah, always a good idea to over communicate on these things. Let people know that you're considering making them the guardians of your children. Let people know that you're considering making them the executor of your estate, and make sure they're up for it. And if you don't have anybody, because some people don't, banks will do it. Mm-hmm. We can talk about that when we meet. Probably, I'd love to say face-to-face because that's what I prefer, but maybe for the time being, most of those meetings will take place over Zoom or over the phone. But yeah, that's something we can address if you're in a situation where you're a little stuck and you don't know who to appoint as your executor.
And given the time, there are probably many questions we're not able to touch on, and some of them deal with personal circumstances. And so Rich and I are very happy to reach out to you, and I've taken down names so we can initiate contact and see if you'd like to set a time to talk. We'd be glad to do that. But maybe one last question to wrap up. Most recently was, what should you prepare prior to making your first appointment with an attorney? And so I think the estate planning inventory is certainly a help there.
I agree. Yeah, the estate planning inventory that I keep showing you will have most of the information that you want to pull together before you go see your attorney. The hardest ones for those of us with minor children or other vulnerable family members is that guardian question. And for those of you that have to make that decision, a couple of things. One is it's probably never going to be needed. But as adults, it's really important that we put that in place. There's no such thing as the perfect guardian out there. So you have to choose a first choice and a second choice that is the best option at the time. You can always change it. But I think a lot of times people get paralyzed with that question, and it prevents them from doing something they really need to do, which is to have something in place. You can always change it. But, a list of your assets and how you hold those assets, a list of your what you owe and who you owe it to, a list of who you would like to distribute your estate to. It's all in the estate inventory if you fill that out before you go see your lawyer. So.
And there was one more question just about how to obtain a copy. And so if you email Rich at rgoode, Goode at DePaul.edu, or me, Mary.Anderson, at DePaul.edu, we'll be sure to get you a copy. And we'd be glad to hear from you. And one last question, Rich. someone is interested in some clarification on the difference between the durable power of attorney for healthcare and a living will.
Sure. So a living will is usually, I know in Illinois it is, it's like a 1-paragraph document that states your preferences if you're ever in a situation where you can no longer make your own healthcare decisions. And it's very broad. And that's all that is. It's just a statement. The power of attorney for healthcare grants someone the power to make your healthcare decisions for you if you're ever in that situation. So that's another thing to think about before you go to see an attorney. Who would I want to be my first option as my agent under my power of attorney for healthcare? Who would I want to be my second option as my agent under my power of attorney for healthcare? And so that person will come in to a hospital, presumably, if I'm laid up and I can't express my own healthcare preferences, show that power of attorney to the hospital, and they will ask them for direction on what healthcare they should provide. So speaking of communication, right? Good idea to talk to that person about what your values are in that regard, what you would want done, what you wouldn't want done if you were ever in that situation. And I hope you never are, and most people really aren't, but it can happen, and we need to have that in place. So one is just a statement. It's more of a fallback if the agent under the power of attorney for healthcare is not available. And the other, the power of attorney, actually gives someone the power to make those decisions for you.
And I would say that you want both, and you can file them now in medical record systems with health systems. And so if you're primarily using one health system, there is a way where you can share those documents so that they can be filed and accessed if you were to be at the hospital and they're unable to determine how to reach your loved ones or your next of kin. And so from working in healthcare, I can tell you that can be helpful too. And it is a blessing to have those conversations about how you'd want people to approach end of life decisions with the people who have to make those decisions. Otherwise, it can really be quite excruciating.
Excellent point, Mary. Well, maybe we should wrap up, huh? Thank you so much for attending. Thank you for helping us beat out wine tasting as the most successful webinar since Shelter in Place started. But seriously, thank you for attending to this important topic. Please use us as a resource, and we would really be happy to help you.